Hey everyone, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to cover the top 5 differences between a living trust and a will. Before we get there, however, if you have any questions about this topic or anything estate planning probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, this question results from many of our clients who come to us asking for a simple will. Often we'll get into the discussions and reviewing their particular circumstances and realize that perhaps they need a living trust. And so we have to get into educating our prospective clients on what a living trust is and how it's different from a will. So there are the top 5 in my mind. First, when that document actually becomes valid. A trust is a contract which is valid upon your signing it, and it's actually valid in all 50 states, which is a plus. A will, on the other hand, is a document that does not potentially become valid until after you're gone and goes through the court system. And that is if there's no hiccups in that road, meaning someone could claim you were incapacitated at the time you signed that will, or that you were under duress. Of course, you're no longer there to claim otherwise. Secondly, by very nature, a last will and testament goes through the probate process. So we have a court involved, and usually that means extra time and money. A trust agreement does not have to go through the probate process. A trust is a private document, and a will becomes public record. That was number 3, I think, if we're counting right. Number 4, a trust does provide additional flexibility. So by that I mean it hands over the reins to your successor trustee at either incapacity or death and makes it a little bit more of a smoother transition to your trusted parties. It does not require necessarily a reliance on a power of attorney as you would have if you had a separate will. Powers of attorney, as a side note, can be difficult to use at times, if not previously submitted to financial institutions. In addition, number 5, I would say, of our differences between a trust and a will is the ability under the trust contract to be very robust in our drafting and to provide for all circumstances. Doing that through a will that would go through a court becomes much more cumbersome and complex. But we're able to do so assuming that the family can work collectively with the professional counsel rather than the court under a trust agreement. Well, thank you so much for listening. And as a reminder, if you have any questions about this topic or anything estate planning and probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. And if you felt that this information was helpful to you, please share, like, and subscribe where appropriate so that you and nobody else misses out. Again, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Thank you so much. Take care.